Hello to you all. My name's Henry Jackson. I'm Chairman of the Board of Francis Burt Chambers, and welcome to the Sir Francis Burt Oration. I'll start with an acknowledgement of country. We acknowledge that we meet on the land of the Whadjuk Noongar people. We acknowledge that the Whadjuk Noongar people did not consent to their land being taken from them, and that dispossession has ongoing legal and moral consequences. We acknowledge that despite that dispossession, the Whadjuk Noongar people have a deep and unique ongoing relationship with the land, and we honour their leaders past and present. We also acknowledge some of the special and distinguished guests here today. I'm not going to name you all, but there are members of the Federal Court, Supreme Court, District Court and Family Court, and Amanda Forrester SC, Director of Public Prosecutions. We're also very pleased that members of the family of Sir Francis Burt are able to be with us tonight, in particular his daughter Sally and her husband Peter. Sir Francis Burt was admitted to practice in 1941 and took silk in 1959. He founded the bar in Western Australia in 1961, and in 1963, with 3 others, established the set of chambers that now bears his name. He was appointed to the Supreme Court in 1969 and was Chief Justice from 1977 to 1988, when he reached the statutory retirement age. While those dates don't amount to ancient history, the passing of 32 years since his retirement means that, in fact, the vast majority of the members of the chambers that bear his name never appeared in front of him, let alone knew him as a barrister. Those who did appear before him speak of his comprehensive knowledge of the law and the clarity, accuracy and brevity of its application. They also speak of his humility, his sense of service and his propriety. Last year, Chris Lester's QC said that no individual judge in Western Australia in living memory has had such an impact on professional standards. The Francis Burt Oration seeks to honour Sir Francis's enormous legacy by asking leaders of the legal profession to share their considered thoughts on present and emerging matters of interest and importance to the legal profession, particularly where the law and the profession intersects with broader society. The original idea for the oration came from Nick Van Hattem, and I thank him again for it. I also thank Pauline McKay and other staff of Francis Burt Chambers, as well as Pip Honey, a member of Chambers and a member of the board, for their efforts in making it all happen, and I thank you all for attending tonight. In just a minute, I will introduce our speaker for the evening, Carmel McLure AC QC. After she speaks, Julie Taylor SC will provide a short reply and a vote of thanks. We'll be finished by 6:30, at which time I invite you all to join us for drinks and canapes in the foyer downstairs. Our speaker tonight is Carmel McLure. Carmel will be well known to many of you. She joined what was to become Francis Burt Chambers in 1995 and took silk in 1997. 4 years later, she was appointed to the bench. She was President of the Court of Appeal from 2009 to 2016. Carmel has also made an enormous contribution to the law in this state, and Francis Burt Chambers is very pleased that she's agreed to present this year's Francis Burt Oration on the timely topic of the rule of law under pressure in an age of disruption.
Thank you very much, Henry. I too would like to acknowledge the traditional custodians of the land on which we meet and pay my respects to their elders past, present and emerging. It was a very great pleasure to receive the invitation to present the 2020 Sir Francis Burt Oration. Sir Francis was a towering figure in the law in Western Australia. He was central to the establishment of the independent bar and then went on to lead the Supreme Court of Western Australia with the highest distinction. I remember him with affection. I made my appeal hearing debut before a quorum presided over by Sir Francis. That's how old I am. I was a greenhorn advocate, but not without a modicum of confidence. The sum total of my oral submissions for the appellant comprised my answers to a continuous stream of probing questions from the Chief Justice. I thoroughly enjoyed the experience and can still bring to mind the feeling of exhilaration when I left the court. And so it was when I came to sit on appeals, I hope to give the appellate advocates before me that same sense of exhilaration. I've taken as my topic this evening the notion of the rule of law. I've done so because its use has become ubiquitous in the international media after the global financial crisis, when populism emerged as a powerful political force in democracies. But the disruption extends beyond populism. It's disruption caused by terrorism, by wars, including the so-called war on terror, the resulting refugee crisis, widespread civil unrest around the world, often involving violence, cybercrime, cybersecurity, an internet-enabled infodemic, and last but not least, the COVID-19 pandemic. In its legal sense, the rule of law is a principle of government and governance of a polity. Whilst the term expressly features in the constitution of a number of countries, not ours of course, and in the Treaty on European Union, none that I'm aware of define it. The idea of the rule of law dates back to the time of the ancient Greeks. The modern scope of the principle is two-pronged. First, that government rules through law and not otherwise, and second, no public official or government is above the law. Under the rule of law, the power of all arms of government, legislative, executive and judicial, is limited by law. Professor Saunders and Leroy provide a more expansive statement of the rule of law in 4 points, and I think this provides the most helpful distillation of the principle. First, the polity must be governed by general rules laid down in advance, which operate prospectively, are publicly available, can be understood and obeyed, and are not changed unreasonably often. So this is a requirement of prospectivity, openness, clarity, and relative stability. This is important for a number of reasons. The governed have to know or be able to discover their rights, liabilities, and duties, and certainty is crucial to economic success. The second point is that these rules, and no other rules, must be applied and enforced, and the application must be faithful, consistent, rational and fair, and no discretion can be unfettered or unconstrained as to be potentially arbitrary. Third, the body that resolves disputes about the rules, courts, must be independent of the other branches of government and of the parties, and disputes must be resolved effectively and fairly. Fourth, in the common law system, which we've got, government itself is bound by the same rules as citizens, and disputes involving governments are resolved in the same way as those involving private parties. However, as the authors explain, in Australia and elsewhere, some aspects of the rule of law are legally enforceable, others explain and justify other enforceable rules, and yet others represent merely goals or aspirations. You'll notice what's missing from this statement of principle is any reference to standards governing the content of laws. A prominent contested issue is whether the rule of law imposes any requirement of substantive justice, such as the protection of some or all of the fundamental rights and freedoms recognised by the common law, which include the right to life, liberty and security of person and property, freedom of expression, freedom of assembly, freedom from arbitrary arrest or detention, the right to a fair trial, and it goes on. There is, of course, a distinction between the rule of law and rule by law. Rule by law means rule by any law laid down by the supreme law-making authority of the polity, regardless of content. That means that there's no minimum moral yardstick of validity or protection against tyranny. As the principle embraces goals and aspirations, and as government in a democracy depends on the consent of the governed, in my judgment, the rule of law must, at a minimum, include a subset of the fundamental rights and freedoms, starting with the right to life, liberty and security of person and property, the right to a fair trial and equality before the law. Just going to the framework in Australia, as you all know, no arm of government and no public official in Australia has unlimited power. The primary and entrenched limitations at Commonwealth and state levels are largely found in the Commonwealth Constitution. Chief Justice Dixon in 1951, in the Communist Party case, said the Constitution assumes the rule of law. The pivotal role of courts in the maintenance of the rule of law sees them ring-fenced effectively in the Constitution. Chapter 3 of the Constitution has the effect of securing the independence and impartiality of federal courts and state courts invested with federal jurisdiction, as well as the right to a fair trial and equality before the law. Judicial review of legislation is the means of ensuring that state and federal parliaments don't exceed their constitutional limitations. The Constitution also entrenches judicial review of Commonwealth and state executive power, which is the means of ensuring government officers, including ministers, act in accordance with the law. As Justice Brennan has said, judicial review is neither more nor less than the enforcement of the rule of law over executive action. As you know, there are a limited number of express and implied protections of rights and freedoms in the Constitution. One is section 92, which we've all been following very closely in the last couple of days, so I won't say anything about that. There are no express guarantees of fundamental rights and freedoms in the Western Australian Constitution. In any event, apart from limited manner and form requirements, its provisions are not entrenched. Insofar as it can be amended, it is, as a wag in the Privy Council said, in the same position as the Dog Act. Not very helpful. So the gaps in the constitutional protection of fundamental rights and freedoms are filled by the common law, but only until such time as the legislature excludes or curtails them. However, as a type of rearguard action, we have the common law legality principle of statutory construction, which you know requires clear statutory language to extinguish or modify the fundamental rights and freedoms which it recognises. So against this backdrop of the legal framework and principles, I want to turn now to some real-life examples from Australia and beyond of laws and conduct that raise rule of law concerns and discuss the role of community consent, trust and responsibility for the maintenance of the rule of law in a democracy. I'm starting with the rule of law in the United States, and why would that be? Even from afar, it's been impossible to ignore the sustained assault on the rule of law in the United States during the administration of President Trump. It serves as a timely reminder of the practical ways and dangers of undermining the rule of law. During his 2016 campaign and after he became president, he engaged in conduct that had the capacity to undermine community trust in the impartiality and competence of public officials in the justice system, including FBI investigators, special counsel, prosecutors and judges, but not, it seems, the police. In particular, President Trump frequently and publicly mocked, derided and criticised individual judges and judicial outcomes. He has referred to the tyranny of the judiciary and in criticising judicial decisions suggested the outcome was driven by political partisanship. This inflammatory rhetoric has the potential to delegitimise the system of justice and thereby undermine the rule of law. Or, if he's correct, and judicial outcomes are indeed driven by political partisanship, then the future of the rule of law in the US is indeed bleak. There are also numerous instances of President Trump's interference in and undermining of the investigation and enforcement of the law, both personally and with the assistance of his second Attorney General, William Barr. I've prepared a paper and I deal with these in my paper, but what they demonstrate in spades is that an independent prosecution service, as we've got in Western Australia, is a vital institution underpinning the rule of law. Now, because of time constraints, I'm going to confine myself to one instance. In his 2020 campaign, President Trump equated the rule of law with his law and order mantra, with his sights trained solely on the unlawful behaviour of some Black Lives Matter protesters, ignoring their claims of systemic failures in the justice system that do in fact undermine the rule of law. That's to be contrasted with the public response from senior judges in state courts after the death of George Floyd. The statement of the Chief Justice of the Louisiana Supreme Court is particularly representative. She said, in quotes, "I firmly believe in the rule of law, but its legitimacy is in peril when African Americans see evidence every day of a criminal legal system that appears to value black lives less than it values white lives." She continued, "Is it any wonder why many people have little faith that our legal system is designed to serve them or protect them from harm? Is it any wonder why they've taken to the streets to demand that it does?" The Chief Justice is articulating an important truth. The legitimacy of an institution of government, including the courts, depends upon the continuing trust and consent of the citizenry. Jeopardise that trust and consent at your peril. It's no surprise that President Xi Jinping of China used the rule of law in exactly the same law and order sense as President Trump when he was talking about the violence in Hong Kong during the pro-democracy protests in 2019-20 and in justifying the imposition of the national security law in June this year. When assessing the extent of the damage President Trump has inflicted on the rule of law, regard has to be had to Theodore Roosevelt's description of the office of the President as a bully pulpit, because it provides a national platform to shape public sentiment and mobilise action. Come now to judicial appointments. The rule of law is an empty vessel if, as a matter of fact, community perception, the judiciary is not both independent of government and impartial. This is a surprisingly common problem, even in advanced democracies. I cannot leave President Trump's America without mentioning the transformation of the federal judiciary. Candidates, as you know, for judicial office are nominated by the President and must be confirmed by the Senate. As at 26 October 2020, the US Senate had confirmed 220 federal judges nominated by President Trump, including 3 Supreme Court judges, 53 appellate judges, and 162 district court judges. And that's more than a quarter of the federal judiciary. Many of the new judges are aged in their 30s and 40s and will be on the bench for decades. There's been such a large number of Trump appointments because when he took office, there were 103 unfilled vacancies in the appeal and district courts and 1 Supreme Court vacancy. The architect and overseer of the transformation process, Senator Mitch McConnell, the Republican leader of the Senate, had refused to proceed with confirming many of President Obama's judicial nominees, including Merrick Garland to the Supreme Court. With the removal of the filibuster, which required 60 of the 100 Senate votes, and the century-old blue slip policy giving senators the power to block judicial nominees from their home state, confirmation now requires only a simple majority. And of course, the Republicans had the numbers in the Senate. A majority of President Trump's appointments had ties to the Federalist Society, a conservative and libertarian group that had a powerful role in the education and the selection of President Trump's nominees. That group assessed who could be counted on to protect conservative interests. The independence of the judiciary, central to the rule of law, is jeopardised if there's a selection, nomination and approval process which only gives the nod to judicial officers that are ideological clones of the government that appoints them. The independence of the judiciary is lost if those same judges don't put ideology aside and conform to the traditional legal discipline by which their powers are closely circumscribed, including by precedent. As troubling as the events in the US is the disaster that's been unfolding in Poland since the electoral success of the populist Nationalist Law and Justice Party, known as PIS. In October 2015, PIS won the presidential election and an absolute majority in Parliament. Shortly thereafter, the government was presented with decisions of its highest court, the Supreme Court, that were not to its liking. During the course of 2016 and 17, the government then secured passage of a number of laws which lowered the retirement age of judges, including serving judges, gave the Minister of Justice the discretionary power to extend the period of service beyond the reduced retirement age, removed the role of the judiciary in the selection of judicial members of the National Council, which nominated judges. Those judicial members on that body are now elected by the PIS-dominated lower chamber of Parliament, and it established a new disciplinary chamber at the Supreme Court, composed of judges selected by the National Council. As you know, Poland's a member of the European Union, and Article 2 of the Treaty on European Union states that it's founded on the values of respect for, among other things, the rule of law. In June 2019, the European Court of Justice ruled that lowering the retirement age of judges and giving the minister power to extend service was inconsistent with the independence required by the rule of law. They said the new system was designed to remove certain groups of judges whilst retaining others. In December 2019, the Polish Supreme Court ruled that the disciplinary chamber didn't fulfil the requirements of independence and impartiality. Despite this ruling, the disciplinary chamber continued to operate, and that caused large public protests in Warsaw in December 2019, and that protest was attended by local judges and other judges from the EU, together with thousands of other people. In January 2020, disciplinary proceedings were commenced against the local judges who participated in the protest. To add to the heat, in January this year, the Supreme Court said that rulings made by judges appointed under the new appointment regime could be challenged. On the same day, the Justice Ministry declared the Supreme Court's ruling had no legal effect, and Poland's parliament passed a law declaring that any person appointed by the president is a lawful judge, and made the questioning of their validity by judges a disciplinary offence, potentially punishable with dismissal. In April 2020, the European Court of Justice granted interim measures suspending the power of the disciplinary chamber to rule on disciplinary cases against judges, and we're still awaiting a ruling. In the meantime, Poland's Constitutional Tribunal, the majority of whose members were elected by the PIS-dominated lower chamber, in fact 14 of the 15 judges were so appointed, handed down a ruling last week that's in line with PIS policy that for all intents and purposes has banned abortion. The public backlash there has been immediate and widespread. Unlike in the United States and Poland, there are no institutional checks and balances on the appointment of judges in Australia. Apart from the requirement to consult State Attorneys General on High Court appointments and minimum professional qualifications, the executive arm of government has the unconditional power to select and make judicial appointments. However, with one notorious exception in Queensland, there's not, to my knowledge, been significant public controversy surrounding a judicial appointment. No doubt there are a number of reasons for this. However, I think a contributing factor is that all involved in the consultation process and those who sit on the opposition benches accept that, save in exceptional circumstances, it's not in the public interest to publicly canvass the suitability of a particular appointee. For the same reason, governments in Australia are ordinarily restrained and respectful in their public reaction to court decisions that disappoint them. What's said in private is, of course, another matter. I want to turn now to security and surveillance, which raises some rule of law issues. There are 80 plus pieces of federal legislation on the subject of terrorism and national security in Australia, 75 of which postdate September 11, 2001. Together they constitute a significant long-term abridgment of human rights and freedoms in response to the tumultuous events of the 21st century. The post-September 11 flurry of legislation in Australia addresses the threats posed by terrorism, cyber security, cyber crime, foreign interference and espionage. I'm going to examine just two of the recent laws and bills that have been introduced into the federal parliament. The first is the National Security Legislation Assistance and Access Act, which creates the novel foreign interference offence. This and other offences in this Act are within ASIO's jurisdiction, and the consent of the Attorney-General is required for a prosecution. The wording of the foreign interference offence is wide enough to criminalise conduct by an Australian citizen that's intended to influence a domestic political or government process or the exercise of a domestic democratic or political right if the Australian collaborates with a foreign political organisation and any part of the conduct is deceptive, or if the Australian doesn't disclose that he collaborated with a foreign political organisation. This is a very significant and I think frankly worrying abridgment of democratic rights. There's the potential for differential treatment of nations, the potential for some McCarthyist-style interrogations, and a government's ideological leanings may inform who gets prosecuted and who doesn't. Someone who collaborated with the Libertarian Americans for Prosperity, funded by the Koch brothers, and communicated its deceptive statements about climate change to an MP intending to influence him in that capacity is unlikely to be prosecuted. The second bill that I want to talk about is the Foreign Relations State and Territory Bill. It gives the Foreign Affairs Minister the power to veto international agreements and understandings reached by public universities and state, territory and local governments. The proposed law gives the Minister wide discretionary power to cancel existing agreements and understandings. It operates retrospectively in the sense that it attaches new consequences for the future to an event that took place before the statute is enacted. It excludes the rules of procedural fairness, but most importantly, it excludes judicial review of the Minister's decision. So there's no way of challenging the legality of the Minister's decision, which of course raises serious rule of law concerns. But the greatest difficulty with national security and intelligence legislation from a rule of law perspective is whether there is or can be any meaningful accountability for the due and proper exercise of the extraordinary powers exercised in that very secretive world. As Justice Gaudron made clear, the practical maintenance of the rule of law requires that someone set the law in motion by taking steps to ensure its observance, and if it's not observed, take legal action if required. If you don't have a person performing that essential function, then the law can be ignored with impunity. A statutory guardian is the chosen mechanism in this country to provide that observance. The Inspector-General of Intelligence and Security reviews the activities of 6 Commonwealth intelligence agencies, including ASIO and ACIS. The purpose of the review is to ensure that agencies act legally and with propriety. The Inspector-General has significant investigatory powers and can initiate inquiries and prosecution and inspections, but the oversight is done in secret and the public reporting is derisory. The Witness K and Bernard Collaery saga gives some cause for concern about the effectiveness of the Inspector-General mechanism. You probably know the story, so I'll summarise it. Witness K was employed by ACIS, our international spy agency. On instructions from the head of ACIS, in 2004, he used deceptive tactics to bug the Timor-Leste Cabinet Room at the time of its negotiations with Australia on the boundaries in the Timor Sea, which would determine the country's respective entitlements to oil and gas reserves. The negotiations resulted in a treaty between the two nations. In 2008, Witness K engaged Collaery, who's a lawyer and former ACT Attorney General, to advise on a claim of constructive dismissal. Later, Timor-Leste commenced arbitration proceedings against Australia in the Permanent Court of Arbitration in The Hague, claiming that the treaty should be deemed invalid because of the bugging. Collaery acted for Timor-Leste in that arbitration. In 2013, Timor-Leste commenced proceedings in the International Court of Justice, seeking the return of documents and other things relating to the arbitration. That had been seized from Cleary's Canberra office under a warrant issued by ASIO. So who thought that was a good idea? Refusing the offer of an undertaking from Australia, the International Court of Justice made an interlocutory order requiring Australia not to use the seized documents, to keep them sealed, and not to interfere in any way in communications between Timor-Leste and its lawyers on the subject of the arbitration. In June 2018, with the consent of the Attorney-General, witness Kay and Cleary was charged with conspiring to breach the Intelligence Services Act for communicating information. It seems the information relates to the contents of an affidavit for an in-camera hearing at The Hague. Unfortunately, from a transparency and accountability perspective, the Attorney-General has issued a certificate under the National Security Information Act that part of the proceedings be held in closed court in the interests of national security. In 2018, several MPs wrote to the Inspector-General asking for an investigation into the bugging. It's reported that the IGS refused, stating, among other things, that if the government required ASIS to carry out the bugging, and that was the allegation that Alexander had instructed the head of ASIS to that effect, it was not for the Inspector-General to scrutinise that direction. So if the Inspector-General has no jurisdiction to review a ministerial direction to ASIS, there can be no meaningful accountability for or judicial review of the conduct, which on any view you might think calls out for further investigation. There are a number of other instances that raise rule of law concerns in Australia, and I'm going to discuss just two of them. The first is Centrelink's disastrous online compliance intervention scheme, better known as RoboDebt. This scheme continued from 2015 until the government shut it down in 2019. However, well before it was shut down, the scheme attracted much media criticism, and the government had lost many merits reviews of RoboDebt claims in the AAT, and these losses were never appealed. In May 2020, the government accepted that the scheme was unlawful and had agreed to pay $721 million. There are over 500,000 individuals entitled to refunds. There's now a class action in the federal court claiming damages on the basis that the government knew of or was recklessly indifferent to the unlawfulness of the scheme. Even if the claimants cannot prove malfeasance, it's a sad indictment that the much vaunted Commonwealth Administrative Law Review system failed to bring the RoboDebt scheme to a much speedier end. And what were the government officers who carry the responsibility under our system for upholding the rule of law doing between 2015 and 2019, one might ask? For the second matter, I return to Western Australia to examine a law that truly shocked me. The law of which I speak is the Iron Ore Processing Mineralogy Agreement Amendment Act. The background in abridged form is that the state of Western Australia entered into an agreement with Clive Palmer's Mineralogy and others relating to potential new mining projects in the north. The agreement was ratified and its implementation authorised by the Principal Act. The agreement provided for arbitration. The state and the other parties to the agreement were in dispute about two separate proposals from Mineralogy and another for the development of an iron ore project. The disputes went to arbitration before former High Court Judge Carmel McLure, and he made two awards against the state. He concluded that the state had breached the agreement and that damages for breach could be assessed. The assessment of damages was listed for this month. The applicants are claiming $30 billion, but that's an ambit claim, I infer. The parties had agreed to mediation prior to the introduction of the Amendment Act. That Act inserts a new Part 3 in the Principal Act and is drafted in extraordinarily wide terms. In relation to, in quotes, disputed matters, which cover the minister's refusals, omissions and requirements relating to the proposal, it's to the following general effect. The first and second proposals are deemed to have no legal effect. Any incomplete arbitration, relevant arbitration agreement and mediation agreement are terminated. The arbitral awards are of no effect and are taken never to have had any effect. The arbitration agreements applicable to the relevant arbitration and award are not valid and are taken never to have been valid. The state has no liability which is extinguished in any way connected with the very widely defined disputed matters. There's no appeals, review or remedy can be pursued in respect of disputed matters, and the rules of natural justice are also excluded. There can be no freedom of information or discovery for disputed matters, and there are extensive indemnities imposed on Mineralogy, Mr Palmer and others to protect the state from loss in the event some third party manages to succeed in relation to those disputed matters. Sections 18 to 25 relate to protected matters, which cover and protect all conduct of the state and a state agent connected in any way with the enactment of the amending Act and the making of subsidiary legislation under that Act. The provisions for protected matters generally mirror those for disputed matters, with one difference. Section 20, subsection 8 provides, and I quote, "Any conduct of the state that occurs before, on or after commencement and that is connected with a protected matter does not constitute an offence and is never taken to have constituted an offence." This speaks to the unique quality of this extraordinary legislation. The government and its officers have got statutory immunity from all liability, civil and criminal, connected with their involvement with the amending Act and its subsidiary legislation. Sections 29 to 31 provide for the making of the subsidiary legislation. The Attorney-General described it as the Henry VIII clause of all Henry VIII's clause, and that's accurate. Section 30 provides that if the Minister is of the opinion that Part 3 does not deal adequately or appropriately with a matter or thing, does not apply to a matter or thing to which it's appropriate for it to apply, applies to a matter or thing to which it's not appropriate to apply, is appropriate to make provision for improving the effectiveness of an indemnity, it's appropriate for this part to be improved in any way, the Minister can recommend to the Governor for the change to be made to Part 3 or make any other provision necessary or convenient, including the retrospective operation. This is the antithesis of the rule of law. But the Amendment Act offends the rule of law on multiple fronts. The state and its officials are not bound by the same law as its citizens, and the disputes with the counterparties were not resolved in the same way. The counterparties are arbitrarily deprived of their property with no compensation, not even a capped upper limit. The awards and arbitration agreements are invalidated retrospectively. The counterparties' public law rights against the state and its officers are extinguished. All legal liability of the state and all in government in connection with disputed matters and protected matters is extinguished and immunity granted. And it delegates primary lawmaking to the executive. The bill for the Amendment Act surfaced without prior notice under cover of the pandemic amidst state government vilification of Mr Palmer for, among other things, his legal challenge to WA's border closure, and had to be introduced and rushed through Parliament with indecent haste in order to attempt to preserve its intent. Whatever criticism can be levelled at the conduct of Mr Palmer and Mineralogy and its counterparties, it cannot, in my view, justify the legislative guillotine of their vested public and private rights and the associated extinguishment of the government's liabilities to them under law. I offer no views on the validity of the legislation. However, I regard it as a serious and unwelcome departure from the high standards of fidelity to the rule of law that the community of Western Australia is entitled to expect. The last topic is the COVID-19 pandemic. Since the declaration of the state of emergency throughout Western Australia on the 15th of March 2020, we've experienced the largest and longest abridgment of our civil liberties in my lifetime, and possibly ever. compulsory quarantine detention, stay-at-home orders, restricted personal movement and association, closed borders, internal and external, and closed businesses, with variations on the theme depending on the extent and any recurrence of the outbreak. The abridgments have been similar around Australia and around the world. In ordinary times, the abridgments would be neither contemplated nor countenanced. A small minority of Australians opposed the measures taken to control the spread of the virus and manifested their opposition on the streets. In America, the resistance to the abridgment of civil liberties was much wider and louder. It's really difficult to let go of the images of the assault rifle-toting mob that stormed the Michigan state capitol to demonstrate their violent opposition to a proposed extension of the state of emergency, which enlivened the abridgment power. President Trump used his bully pulpit to encourage resistance to lockdowns and closures in Michigan and elsewhere. Unsurprisingly, perhaps, in October 2020, 6 men were charged with offences arising out of their detailed plan to kidnap the governor of Michigan, who was the focal point of the anti-government anger over the coronavirus measures. The deep partisan divides in the American community are on show again in their response to the pandemic. The primary law for emergencies in this state is the Emergency Management Act. In April 2020, that act was amended to address inadequacies exposed by the challenges presented by the pandemic. The explanatory memorandum acknowledges that the amendments introduce what might otherwise be considered extraordinary provisions. Indeed, a number of the amendments are made retrospective to ensure the validity of directions already issued. A new and very wide power is given to authorised officers to, in quotes, take or direct a person or class of person to take any action that the officer considers is reasonably necessary to prevent, control or abate risks associated with the emergency, and there's no limitation on who can be an authorised officer. In recognition of the breadth of this power, it's the subject of a 12-month sunset clause. A proposal to include a similar power in Victoria attracted a storm of opposition and a retreat by the Andrews government. Moreover, the amendments abridged the usual notification requirements. A direction in relation to a class of person or thing need not be given directly to the person to which it applies and need not be published in the Gazette. It's sufficient that the Minister considers publication in a manner that's suitable in the circumstances. So directions and declarations under the Act, of which there were many, many hundreds, some of which changed with great frequency, were published on the state government website. The Act as amended and the directions don't satisfy all of the rule of law requirements of prospectivity, openness, public availability, clarity and relative stability, which I suspect would be characterised as aspirational in this context. And the wide scope of the powers, including the power to exempt people from the directions, has the potential to be arbitrarily and inconsistently exercised. Sensibly, the application and enforcement of the law was moderated to ensure that people had a proper opportunity to know and understand their obligations before a penalty was imposed, and with the benefit of regular, detailed explanations of the scientific and health reasons for the acute disruptions to daily life, the community largely cooperated. There's no doubt the directions under the Act placed very significant limitations on the fundamental rights and freedoms recognised by the common law and on the entrenched rights protected by Section 92. As to the latter, we'll know in due course what the High Court thinks about our border closures. As to the former, the question whether the Parliament clearly manifested an intention to limit the relevant common law rights is the question, and the answer might vary if the statutory powers continued to be exercised after the immediate emergency had passed, something we'll have to see. Moreover, even if the law and directions did place limitations on some other constitutionally entrenched rights and freedoms, the limitations would be subject to a proportionality test similar to that under international law, which requires that limits on a human right must be prescribed by law, be in pursuit of a legitimate objective, be rationally connected to its stated objective, and be a proportionate way to achieve that objective. Even in the US, with its constitutional Bill of Rights and libertarian drift, the entrenched rights are not absolute, although where there are conservative judicial majorities, the wriggle room is very narrow. So whilst we're still in the midst of a long and challenging period of disruption with uncertain horizons, I think it's timely to reflect on the wisdom of the great American jurist Learned Hand in his 1944 America Day address on the spirit of liberty. He said, "Liberty lies in the hearts of men and women. When it dies there, no constitution, no law, no court can save it. And what is this liberty which must lie in the hearts of men and women? It's not the ruthless, the unbridled will. It's not the freedom to do as one likes. That's the denial of liberty and leads straight to its overthrow." He went on to say that the spirit of liberty is the spirit which is not too sure that it's right, which seeks to understand the mind of other men and women, and which weighs their interest alongside its own without bias. In this address, the judge effectively places ultimate responsibility for the maintenance of a democratic state on the character of its people. That's a big call, but still a correct one in my view, notwithstanding that we, the people, are faced with new and daunting challenges in a world dominated by the internet and social media and the social media services it spawned. It's said that most people now get their news on social media, which is not mediated or filtered for truth, that social media captures, consumes and manipulates users' attention, reducing the scope for shared open space for political discourse, that it produces ecosystems of online information that are echo chambers for people with shared interests or ideologies, that it promotes an age of post-truth politics where our leaders can mislead or even lie with little or no electoral consequences, and where foreign bots can unleash a fire hose of falsehoods to inflame division and discord within a polity. For all that, Australians can take some comfort, I think, and reassurance from the considered and almost entirely measured response to the drastic action taken during the pandemic in order to protect the community, in particular the most vulnerable among us. That empathetic and communitarian approach reminded me of the overwhelming positive response of the Australian community to the 2017 Marriage Law Postal Survey, which our federal government intended as a roadblock. It's clear that our spirit of liberty is not lost, but it's also clear that we must be vigilant in its protection, because we, the people, who must hold politicians and governments to account, are the ultimate guardians of the rule of law and the democracy that depends on it. Thank you.
Thank you, Carmel, for that fabulous talk. I just wanted to start by making this reflection before turning to the substance of the talk. For me, as a young woman, youngish woman, embarking upon a new career as a silk in this state, I just wanted to comment on the importance of having people who have proceeded successfully before us. Justice McLure is obviously an icon of our local profession, and it makes an enormous difference to know that there have been people who have come before us so successfully and succeeded as women in the profession. I feel that we really are standing on the shoulders of a handful of giants, and we were very fortunate to hear from one of them tonight. One of the interesting aspects for me of Justice McLure's talk is the interaction between justice or morality and the validity of laws. And it's an issue that arises in particular in relation to the Iron Ore Mineralogy Act, of which Justice McLure spoke, and also laws such as the response to COVID and the public response in terms of obedience or civil disobedience to those laws. And the issue of validity and its interaction with morality are most pertinent in times such as current ones, in times of major disruption. As Ronald Dworkin famously taught, and as everyone here knows, it is the hard cases that test our understanding of the rule of law and our choices in striving to uphold it. Is a morally unjust law a law that is a valid law? Many adherents to the school of positivism Positivism would of course say yes, an unjust law is a law, although Parliament shouldn't be surprised if people choose to take civil disobedience in relation to it. HLA Hart explained that every legal system is a union of obligation imposing or primary rules and power confirming or secondary social rules. In our legal system, the most fundamental secondary rule is the rule or rules of recognition, which specify the ultimate criteria of legal validity. In our case, what Parliament enacts is law. In WA, that is conformity with the Commonwealth Constitution and other imperial acts of Parliament, which provide the rules by which we determine what is a law. Applying this philosophy in relation to the hard cases that Justice McLure has raised in this contemporary time of disruption, an answer to the question, is an unjust law a law, might be that the law is valid and hence a law if enacted by Parliament in conformity with and without breach of the applicable constitutions, regardless of the moral standing of the law itself or the conformance of the legislation with other criteria of prospectivity, openness, public availability, etc., whether disproportionate or otherwise. The advantage of such a theory in the context of most hard cases is that, at least in a functioning democracy such as ours, the test of what is the law and must one follow or uphold or enforce it is readily ascertainable by reference to the applicable rules. In an advance copy of Justice McLure's speech, she referred in relation to the COVID pandemic to the comments of Jonathan Sumption, who apparently publicly said that the equivalent UK laws were despotic and wicked and he would not be following them. Since receiving that speech, or that advance copy of the speech, I've been scouring the footage of and photos of London in lockdown, and I've not yet seen Mr. Sumption wandering the streets in defiance of the local law. Perhaps he had a change of heart, but the declaration by such a distinguished judge of the common law world that he would not follow the law is intriguing. Does he have to follow a bad law, and why do we as lawyers uphold them? Some people think that a morally unjust law imposes legal obligation, but not moral obligation. Natural lawyers have a theory that the law is an effective way of coordinating society to achieve basic social good, and therefore one ought morally obey the law. Where the law is morally unjust, it does not meet this function, so that one might think there is no moral obligation to obey such a law, thus giving Mr. Sumption a defence. But at least in Australia, where there is a strong democracy and the validity of laws can be tested by the exercise of judicial power, independent and separate from the legislature, it seems to me to be morally important to ensure that the law is stable and upheld so as to protect the legal system itself. Our legal system is good. So we have a moral obligation to follow the COVID laws, whatever other laws that are thrown at us, despite what we might see as the despotic or wicked nature of them, for the sake of not undermining the legal system, which is generally morally valuable. Legal officials, all of us here, barristers, judges, solicitors, officers of government, have a moral obligation to obey and enforce the law for the same reason, even a law which is not itself morally valid. Justice McLure's invocation of the phrase "we the people" is important. We've heard it a lot in the last few days, particularly yesterday. In the Western world, we the people do have significant challenges. The rule of law is important, but it can only go so far. As Ruth Bader Ginsburg said, a constitution, as important as it is, will mean nothing unless the people are yearning for liberty and freedom. In her book, I Know This to Be True, Ruth Bader Ginsburg referred to the same passage that Justice McLure did in relation to sacred liberty and said, "May the spirit of liberty, as Judge Hand explained it, be your beacon. May you have the conscience and the courage to act in accord with that high ideal as you play your part in helping to achieve a more perfect union." All of us here carries the heavy burden in our work as guardians of the legal system, In times of disruption more than ever, it is important for us to pause and consider the validity and the strengths and weaknesses of that system and our preservation and perpetuation of it. With those words of reflection, I offer my sincere thanks on behalf of the members and friends of Frances Burt to Carmel McLure for her very fine talk, and I ask you all to help me to express our thanks in the usual way.